Good morning, good evening, ladies and gentlemen. Welcome to our webinar series on the national security law that the Faculty of Law at Hong Kong U has been organizing. My name is Fu Hualing. I'm the Dean of the Faculty. So on behalf of the faculty, I would like to extend a very warm welcome to all of you in this very hot day. So the pandemic has made it possible to have a global seminar in the early morning of Saturday with friends and colleagues participating from different parts of the world. I thank you for your attention and your support. Today, we're going to talk about academic freedom and national security law. Our panelists will raise issue of concerns. I know it is pervasive, clarify doubts if we could. We'll also talk about the existing safeguards in domestic and international law, and indeed safeguards built in the national security law. Of course, there are also soft laws, codes of conduct in the university, which are also tremendously important. Most importantly, we'll talk about the ways to move forward, to face challenges, and to maintain academic freedom, intellectual integrity, and university autonomy. Academic freedom challenges to it is a global concern. As early as 2003, the American Association of University Professors released a wonderful report entitled Academic Freedom and National Security in a Time of Crisis. I was going to use this title as our title today, which addressed the concern, of course, the post-9/11 in the post-9/11 area. Last year, the Australian government released the report of the independent review of freedom of speech in Australian higher education providers, which was undertaken by the former Chief Justice of Australian High Court. For those who are interested, I would strongly recommend those reports to you. The vulnerability of academic freedom is not a new issue for Hong Kong or Hong Kong U either. It has been tested, defended, and upheld several times. Indeed, our constitution, the basic law, specifically protect academic freedom precisely because of its value to us and the fragilities to sustain in Hong Kong. The national security law is a new round of challenges before us. We are facing up to those challenges, and that is part of the reason why we're here to talk about academic freedom in Hong Kong. Today, we are honored and privileged to have three distinguished speakers to join us to share their thoughts on academic freedom and national security law from different perspectives. The first speaker is Professor Carole Petersen from University of Hawaii. Carole is a former colleague at Hong Kong U, who has written extensively on academic freedom in Hong Kong. She's going to talk about a proposal, what she called the bottom-up approach to protecting academic freedom in the shadow of the national security law. So, Carole, the floor is yours.
Thank you very much, Hualing, and thank you so much for inviting me to speak. It's wonderful to see all of you again, even if it's only virtually. So the meaning of a bottom-up approach refers to my proposal that I don't think academics in Hong Kong should wait until senior management suggests policies in light of the national security law. I think that academics have to get very busy and start having discussions in your departmental levels and share possible drafts of policies and really think very carefully about how to robustly defend academic freedom. So if we could move to the second slide. Could you move to the second slide, please? Thank you so much. So as Hualing mentioned, we have constitutional protection in the basic law, but one of the reasons we do is that the Sino-British Joint Declaration also anticipated that Hong Kong residents would be nervous about academic freedom. And so paragraph 5 of the Joint Declaration and also Annex 10 expressly protects the freedom to conduct academic research. It also says that the Hong Kong government shall determine on its own all policies in the field of education, and that academic institutions and students should have autonomy in the field of education. Could we go to the next slide, please? So in practical terms, the more important provisions are, of course, in the Hong Kong Basic Law, because that's Hong Kong's constitutional instrument. And these provisions can actually be enforced if the government tries to infringe someone's academic freedom. So, of course, Article 27 is important. That protects freedom of speech, the press, and publication. Article 34 expressly mentions freedom of academic research, literary, and artistic creation. Article 39, which Kelly is going to talk about more, provides that the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights shall remain in force in Hong Kong, and they both have provisions that are relevant to academic freedom. And then Articles 136 and 137 essentially repeat those two provisions from the Joint Declaration, saying that the government should formulate education policies on its own, and that Hong Kong's educational institutions shall retain their autonomy. Could we go to the next slide, please? So the reason I included slide 4 on the Robert Chung affair is it is one of those early tests of academic freedom that Hualing referred to. And I think it's important because it demonstrates that interference with academic freedom doesn't always come from a criminal law. It doesn't even always come from overt discipline actions by a university against an academic. Very often it's subtle pressures that are the true interference with academic freedom. And so many of you will remember this case. In 2000, Dr. Robert Chung revealed in an article in the South China Morning Post that while he was a PhD student the previous year, a message had been sent to him, and it had been sent to him that Tung Chee-hwa, the first chief executive of Hong Kong, was not happy with his public opinion research project. And at first, he did not declare who the messengers were, but then he was put under some pressure by actually spokesmen from the government who didn't really believe him, I guess, that he should declare who did this. And he finally came out and said, well, actually, Hong Kong U's vice chancellor sent a pro-vice chancellor, who also happened to be Robert's PhD supervisor, to tell him that this was not a good idea, this public opinion poll research project, which was, by the way, reporting on the popularity of the current government. Eventually, the vice chancellor of Hong Kong U had to resign, but that was only because there was an independent investigation panel which held hearings that were televised so everyone could see what was happening. And their report was quite controversial. And there was some concerns at first that the report might not be received and adopted by Hong Kong U's council. But at a certain point, more than half of Hong Kong U's academic staff signed a petition asking Hong Kong U's council to accept the panel's report. And it was at that point that the vice chancellor decided to resign. So it's a very important example of how threats to academic freedom don't necessarily come from legal sources, right? They can come through a friendly visit from your supervisor, but it's also important to show how significant it is for someone to be brave enough to come out and air what happened and for colleagues to rally around. Now, after that incident, Hong Kong U did set up a task force on academic freedom. And if you Google academic freedom in Hong Kong U, you can still find the report of the task force and this statement that regretfully we found evidence that a number of colleagues had felt their academic freedoms had been infringed. That task force recommended that a mechanism be created for complaints. But to this day, I can never find that mechanism. I keep asking people, what is the mechanism at Hong Kong U? And I guess you would go to your department head, but I really think we need a more effective mechanism at the university. Next slide, please. So one of the worries I have has to do not just with the national security law, but with the fact that Hong Kong's universities have gone through governance changes in the structure since the Robert Chung affair. as a result of a couple of management review reports, which I've put on the slides, the universities in Hong Kong now have a much more top-down structure of governance. For example, the university councils are very powerful, and they're also less representative of the university community. They have far more people from outside the university. And in 2006, my co-author, Professor Jan Curry, for our book on academic freedom in Hong Kong, she conducted a number of interviews, extensive interviews with academics in Hong Kong. And our conclusions were, in a nutshell, that academic freedom was still quite robust at that time, but that it was increasingly becoming vulnerable, partly due to pressure to collaborate with mainland Chinese institutions, which means you don't want to offend the central government, but also due to these structural changes. And we wrote a follow-up article in 2008 where we concluded to quote, "A management system that works in Boston, London, or Sydney might be disastrous in Hong Kong due to the lack of democracy and due to the influence of China." And we were referring to the fact that these management changes had usually been recommended by foreign experts, but foreign experts usually from democratic nations who didn't perhaps understand all of the challenges that Hong Kong academics face. Next slide, please. Now, when we fast forward to this decade, you start to see, I think, why these governance changes are so significant. And it's basically because increasingly we see the appointed government coming into conflict with the pro-democracy movement, and particularly with the students. The student movements have become much more active in Hong Kong in recent years. 2012, you saw the students being the organizers really of the anti-patriotic education movement, and many really finding their political voices. Students were very active in 2013 and 14 on the debates on democratic reforms. And in my opinion, it was really the students who launched Occupy Central. I know we tend to think of Benny Tai and his colleagues as coming up with the idea for Occupy Central, but really it was after the August 31st, 2014 decision by the NPC Standing Committee where the students actually rushed to the city, and they're the ones who started Occupy Central. And I think it was their energy and their emotions that made it a much larger, much more sustained occupation than probably Benny Tai and his colleagues ever really expected. Since then, I've been studying the backlash, what my colleague Alvin Chung and I called, the kind of Beijing's retribution, if you will, for Occupy Central. I think we started to see far more interferences in freedom of expression. Of course, you saw the disappearing booksellers, which is a severe threat, I think, to the freedom to publish. But we also saw controversies at Hong Kong U concerning the council's decision not to confirm the appointment of Johannes Chan as a pro-vice chancellor. And we did extensive interviews again for this 2017 article, and we found many colleagues were reporting very different feelings about academic freedom than they reported in 2002 and 2003. They were starting to say things like, "I'm keeping my head down," or "I'm counseling junior untenured colleagues not to engage in certain research. I'm not seeking funding from foreign foundations anymore because I'm afraid it would count against me." So that was the backlash that we reported on in the 2017 article. And now I think the question is, what's going to happen as a result of this new law? Because now we really do have not just the potential for subtle pressures, not just the potential for maybe not getting tenure, we actually have the potential for being criminally prosecuted. And so that's a much more serious threat. So in my opinion, because of these broadly defined offenses, and in a moment I'm going to look at a few of them in particular, and because of the blurry jurisdictional lines, because of Article 55, which says that in certain cases, the central government could actually take jurisdiction over the case, I think we're going to see many more people exercising self-censorship, many more people maybe being afraid to take positions at Hong Kong's universities, which would greatly undermine the international character of Hong Kong's universities and its international reputation. We may even see some targeting by the government against educational institutions. And the reason for that is, I say that, is that I'm often hearing either pro-government or actual government spokesmen blaming the 2019 protests on radicalized students or teachers who have radicalized their students. In addition to, of course, constantly blaming foreign forces, although I don't really think there's a lot of evidence that's ever been presented for that. But whether it's true or not, I think there are people in the government and in the police who may feel we are going to try to nip protests in the bud by interfering more in academic communities, both with students and with academics. So that's why I think we really need to start thinking about a bottom-up approach, one that drafts robust policies using Article 4 of the National Security Law, which says that the ICCPR and the International Covenant on Economic and Social and Cultural Rights will continue to apply. We have to use that to draft robust policies to interpret the provisions in the National Security Law as much as possible to comply with the ICCPR. So if we could have the next slide, please. So the last few slides just have some examples for you of vague language in the national security law, which I think could create real worries for academics. So let's look first at Article 20, the definition of secession. It says that a person who organizes, plans, commits, or participates in any of the following acts, whether or not by force or threat of force, with a view to committing secession or undermining national unification, which is kind of a vague mens rea, in my opinion, shall be guilty of an offense. And these three following acts are separating the Hong Kong SAR or any other part of the PRC from the PRC, altering by unlawful means the legal status of the SAR, Hong Kong SAR, or any other part of the PRC, or surrendering the Hong Kong SAR or any other part of the PRC to a foreign country. And then you have to look at Article 21, because Article 21 is the incites, assistance, abets, or provides assistance to. So query, here's a hypothetical. We all know that China has many territorial disputes with other countries, disputes with India, disputes with Vietnam, there's the 9-dash line in the South China Sea. Well, what happens if there's an academic research project or an academic article on those disputes? Right? What if the research doesn't support the People's Republic of China's view of that territorial dispute? Now, in my opinion, if you interpret Article 20 and Article 21 to be consistent with the International Covenant on Civil and Political Rights and to be consistent with the human rights provisions of the Basic Law, then those academic studies and reports should not be considered offenses under Article 20 and Article 21. But I think it's really important that academic institutions get out there and take that position publicly so that academics can feel comfortable that if I'm criticized for my research, then I know that my university, my institution, and my colleagues share my view that this is not a criminal offense, that we have to interpret these offenses narrowly so as not to violate the ICCPR. Next slide, please. So Article 29, collusion with a foreign country or external elements, is another really broadly drafted provision. It's so long, it takes up a huge page. It would take probably 2 or 3 slides if I were to quote entirely from it. And so I just highlighted some of the clauses that really concern me. In essence, Article 29 makes it an offense to request or to directly or indirectly receive any support or instructions from a foreign country, institution, organization, or individual to do any of the following. One of them is seriously disrupt the formulation and implementation of laws and policies by the Hong Kong or central governments, which is likely to cause serious consequences. Another is to impose sanctions or other hostile activities. Now, I think I know what sanctions are, and I'm always very careful not to call for any, but I'm not exactly sure what hostile activities means, right? That could be a very broad provision. Provoke by unlawful means hatred among Hong Kong residents for the central or local or Hong Kong governments, which is likely to cause serious consequences. Now, once again, if you read this very broadly, you could imagine situations in which Article 29 could actually violate the ICCPR and several human rights provisions in the Basic Law. Academic research is often critical of government policies. Academic research is also often relied upon by stakeholders to try to pressure the government to change its policies. I mean, we've all seen over the last 3 decades academic research that was used to pressure the Hong Kong government to enact laws against discrimination, or to persuade the government to change its housing policies, or to treat migrant workers better, or to adopt different policies on COVID-19, right? It's also very common for Hong Kong academics to collaborate with researchers from abroad. So if you publish a research study, which is then used by a pressure group to seriously criticize Hong Kong government policies, and the Hong Kong government says you are disrupting the implementation of policies that we wanted to implement, and oh, by the way, you got assistance from a foreign researcher or some foreign foundation that helped to fund your research, is it possible that you could find yourself entangled in an Article 29 charge? I hope not. In my opinion, if you read Article 29 so as to comply with the ICCPR, which is the way I think it should be interpreted, according to Article 4 of the National Security Law, then it should not be interpreted that broadly. But I think we need to give academics confidence, otherwise people are going to be practicing self-censorship. All right, could I go to the next slide, please? So this is my final slide, and I hope I've stayed within time, Hualing. I'm trying. Basically, I mean, I know it's a lot easier to suggest things when you're not in the academic, I'm not in Hong Kong U anymore. And so, of course, it's for Hong Kong academics to really decide how they want to approach it. But these are some suggestions that I hope you would at least consider. I think every university needs a very robust policy. I don't think it's wise to wait for senior management to come up with some umbrella policy for your entire university. If you do that, you might not be happy with what you get. I think faculty need to start their own discussions and their own drafting exercises at the departmental level, because only you, thinking about your research projects and your teaching, you have a better idea than senior management how this law might affect you. And then I think it's important for academics to get together across departments to brainstorm, share your draft policies, and don't forget the aiding and abetting offenses, because sometimes you might be at risk, not just because of what you did. You might not have advocated anything, but you might have produced some research that someone else uses to advocate something. And that could potentially get you into trouble if the offenses are read too broadly. I think when you draft these policies and you advocate for a wide space for academic freedom, it's really important to emphasize the importance of research and knowledge sharing to your university's mission and to the rankings of your university, frankly, which senior management usually cares about. You might cite the criteria and the research assessment exercises, which emphasizes knowledge sharing and the relevance of your research. I also think you need to think about the importance of your teaching. And in some disciplines, there's a lot of clinical teaching, and that's stressed. Experiential learning is good for students. Students need to learn by doing things in the community, but that inevitably brings certain faculty and students into the community. And they may have interactions with NGOs who may be advocating for certain things that the government doesn't like. So think about that, not just your research, but also the role of your teaching. And I would also call for regular training on academic freedom at the departmental levels. And I think there should be a formal, well thought out complaints mechanism. And I think it should be available to faculty in their departmental level. They should have the option to go to one of 2 tenured members in the faculty to receive complaints. They also should have the option, if they don't feel comfortable complaining within their department, to go outside their department. And I said in my slide that I think this is comparable to developing a policy against sexual harassment. You have to make sure that a person feels they can raise concerns without fear of retaliation. In some cases, that might be raising a complaint about interference. In other cases, it might just be seeking guidance, right? I need to know, am I risking liability by entering into this research project or teaching this course? And then finally, I hope that this is the start of a conversation. There are many academics out there who I think are interested in academic freedom, and they find Hong Kong always a fascinating place to study. And I hope that we can start databases where we're collecting evidence of surveillance if it's occurring, self-censorship if it's occurring, and also evidence of these policies. And I think we can learn a lot from comparative experience, and I know Robert's going to speak about that later. I'm particularly worried about self-censorship, and I added to the slide at the last minute the example of RTHK pulling the interview that they had posted initially with Nathan Law. And I thought, isn't that interesting? We don't even know for sure if Nathan Law has done anything. I mean, he's innocent until proven guilty, right? And yet, all of a sudden, our public radio station felt they had to pull that interview. And I think that's very worrying, and it is a sign of things to come in the academic world unless we get busy and really robustly defend academic freedom. So with that, I'll close, and thank you very much for your attention, and look forward to our discussion afterward.
Thank you. Thank you very much, Carole, for making the wonderful recommendations. I think we are encountering the concerns on a daily basis. I mean, just giving an example is, should we encourage students to read Benny's work, right? So actually, I think not only in our law school, the other law schools have encountered the same questions, right? Should we use articles written by Benny on constitutional reform, given the consequences? So 10 years ago, I think the research result was Hong Kong U was the academic freedom was robust but vulnerable. Now I was thinking how to characterize the situation. Probably I would say vulnerable but robust. So if you have any questions for Carole, please just type in so Carole can look at the questions and prepare the answers. Now let's move to the second speaker, Kelly Loper. Kelly is associate professor in our faculty. She's a colleague. She was the director of CCPL, and she heads the human rights program. Kelly writes on equality rights, among many other things. Today, she's going to talk about international standards supporting academic freedom. Kelly.
Okay. Thank you very much, Pauline. Let me just try to share my screen. Give me a moment. Hopefully that's working. Yeah, thank you very much for organizing this forum. I mean, it's an incredibly important discussion. And also thanks to Carole for that great presentation. I think you've made quite a few very practical suggestions for moving forward. And what I'd like to do now is pick up where Carole's left off and look more closely at some of the tools and approaches that we might be able to use to promote this robust vision of academic freedom, and also to respond to some of the uncertainties that we're facing that Carole has also mentioned, the vague provisions in the law. What does the law actually mean? How is it going to be implemented in practice? How we might mitigate the anxiety and the confusion that I know many people are feeling. The tools that I suggest that could contribute, which Carole has alluded to, are the international standards mentioned in the national security law itself. And Carole's already talked about the specific provisions in the basic law on academic freedom. And I want to build on that by looking more closely at the provisions in the ICCPR, the Covenant on Civil and Political Rights, and the ICE-SCR, the Covenant on Economic, Social, and Cultural Rights, that support academic freedom in various ways. Let's see if I can, yeah. Okay, well, first of all, a quick note about how international human rights law applies in Hong Kong. Hong Kong is bound by 7 of the core UN human rights treaties, and they're all arguably relevant to academic freedom in various ways. But 2 of them have special status in Hong Kong's domestic legal system, which makes them particularly influential, I think. And of course, these are the ICCPR and the ICE-SCR. And Article 39 of the Basic Law guarantees that the provisions of both treaties shall remain in force and be implemented through the laws of Hong Kong. And it's notable that the ICCPR in particular has continued to apply beyond 1997, since it still doesn't apply to mainland China. And this has been a key feature of Hong Kong's autonomy in line with the one country, two systems principle. The ICCPR has been incorporated into Hong Kong's constitutional framework to a greater degree than the ICE-SCR. The ICCPR's constitutional status has been reinforced by the Bill of Rights, which essentially duplicates most of the provisions in the treaty, but there's no equivalent to the Bill of Rights for the ICE-SCR in Hong Kong. And so it's arguably had less of an impact. Article 4, which Carole has mentioned, of the National Security Law also mentions both treaties. It provides that human rights shall be respected and protected in safeguarding national security in Hong Kong. The rights and freedoms, including freedoms of speech, etc., and the provisions of the ICCPR and the ICE-SCR shall be protected. Now, before I get into more detail about how these treaties support academic freedom, I want to address what might be an elephant in the room, or I guess I should be saying an elephant on Zoom. Many people have questioned whether Article 4 has any value. So in other words, is it simply window dressing? Will it really make any difference? And I don't think we have the answer to that yet, but I do think that Hong Kong courts will try to interpret any vague language in the national security law as consistent with the rights in Article 4 whenever possible. And the courts have extensive experience adjudicating human rights cases with reference to international standards and comparative human rights materials. And there's already some initial evidence that they will take Article 4 seriously. The Court of First Instance recently denied leave to a judicial review application that was related to the introduction of the NSL. And although the application was unsuccessful, the court explained that if there were to be a concrete case, that it would have to consider whether the NSL and the basic law are consistent. And this is due to common law principles, the court's constitutional responsibility to protect rights under the basic law, and Article 4 of the National Security Law. Now, I would also suggest that Article 4, and therefore the ICCPR and the ICE-SCR, can support efforts beyond the judicial realm. In particular, and for the purposes of our discussion today, I suggest that Article 4 could allow Hong Kong U and other academic institutions to rely on the ICCPR and ICE-SCR when formulating their policies and mechanisms that promote a more robust understanding of academic freedom. And this vision of academic freedom grounded in international human rights law could come from the top, from the university management and the governance structures, or from the bottom up, as Carole has suggested, within each faculty or discipline, or hopefully both. So what are the international human rights standards that support academic freedom? Unlike the basic law and some other constitutional documents around the world, there's no explicit right to academic freedom in either the ICCPR or the ICE-SCR. But the UN human rights treaty monitoring bodies have started to clarify that a right to academic freedom can be derived from other rights. And arguably all of the provisions in both treaties apply, but I'll focus on two of the most important in the interest of time. The first is the right to freedom of expression in the ICCPR, which is probably the most evident to many people. And the second is the close connection between academic freedom and the right to education in the ICE-SCR. And I don't have time to consider others, but I just want to flag for reference that non-discrimination is very relevant, and particularly non-discrimination on the grounds of political opinion. Freedom of movement is also important. There have been cases in some jurisdictions of travel restrictions being placed on academics, preventing them from sharing their research at international conferences, for example. Of course, freedom of association, freedom of assembly are important. Freedom from arbitrary detention is relevant. So in some places, academics have been detained for publishing articles critical of government policy. Also, Article 15 of the ICE-SCR is very important since it provides a right of everyone to enjoy the benefits of scientific progress and creates a duty, according to the Committee on Economic, Social, and Cultural Rights, to enable a participatory environment that protects and promotes academic and scientific freedom. So here are the first two paragraphs of Article 19 of the ICCPR and Article 16 of the Bill of Rights. You'll note that the second paragraph is especially important because it guarantees the freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers. And it sounds very much like our job descriptions at universities. It's very much the kind of work that we do at academic institutions. Now in this slide, I've just summarized a few points about the nature of Article 19.2. And as explained by the Human Rights Committee in a general comment on the subject, and the Human Rights Committee is the monitoring body for the ICCPR. Now, according to the committee, the right to freedom of expression is very broad in scope. It includes the expression and receipt of communications of every form of idea and opinion capable of transmission. Now, this might be political discourse, commentary on public affairs, discussions of human rights, journalism, teaching, etc. It embraces expression that could be regarded as deeply offensive to some people, and there are some limitations, which I'll get to in a moment. It includes the freedom to criticize the government and political leaders. So again, I think it's clear that the breadth of Article 19 would certainly encompass many of the academic activities that we partake in teaching, learning, research, the generation and dissemination of knowledge, etc. Now, some UN human rights mechanisms have recorded a variety of violations of the right to freedom of expression related to academic freedom. And these are just a few examples in the slide. So for example, suppression of research on controversial topics, such as the national independence movement that was active in the past, bans on campuses of independent organizations that are considered political, etc. And this is from a report in 2000 published by the UN Special Rapporteur on the right to freedom of opinion and expression. And I note that the outgoing Special Rapporteur on the right to freedom of opinion and expression is about to publish a new report on academic freedom later this year. So the right to freedom of expression is broad, but it's not absolute, and it can be restricted in certain ways, but the restrictions have to be necessary only for a small number of particular reasons, which include national security, and these are all set out in Article 19.3. And restrictions on this right can't be too broad. They need to be appropriate and the least intrusive option for achieving the protective function. They have to be proportionate. And because there's a presumption of freedom, states have the burden to demonstrates specifically the precise nature of the threat to national security in order to rely on this limitation provision. And Hong Kong courts have developed a similar proportionality test based on these standards in cases involving freedom of expression, including cases involving academic freedom. Now, in the same general comment, the Human Rights Committee has also explained that the state cannot invoke national security laws that have the effect of suppressing information of legitimate public interest that doesn't harm national security. And also the prosecution of researchers and others for disseminating such information is not allowed. Now, moving on to the ICE-SCR, the right to education in Article 13 also provides a great deal of support for academic freedom. And in this slide, I've summarized some points from a general comment published by the Committee on Economic, Social, and Cultural Rights. And this document actually includes several detailed paragraphs focusing on the importance of academic freedom. And I've just included a few highlights. First, the general comment explains that the right to education can only be enjoyed in association with academic freedom. So in other words, academic freedom is required in order for the right to education to be fully realized. Academic freedom includes the freedom to pursue, develop, and transmit knowledge and ideas through research, teaching, study, discussion, etc. It also includes the freedom to express critical opinions about the institution within which academics work, and also to fulfill their functions without any discrimination or fear of repression. Self-governance is required, so academic freedom means both institutional autonomy as well as individual autonomy. And the committee notes that academic freedom also entails obligations. And these include respect for the academic freedom of others and ensuring a fair discussion of contrary views. And this particular portion of the general comment was actually cited favorably by a Hong Kong court in a case involving academic freedom back in 2009. So this is just a snapshot, but hopefully it gives a sense of the standards in the ICCPR and ICE-SCR that create negative and positive obligations on governments to protect and promote academic freedom. And they also provide a developing picture of what academic freedom looks like in international human rights law. Now, of course, as I mentioned at the beginning, there are still a lot of gray areas, which Carole has talked about, the uncertainties about the potential impact of the law in the academic context. So will it prohibit publication of research on certain controversial topics? Can we receive research funding from certain foreign institutions? I mean, this is many of the issues that Carole has already mentioned. And I don't know the answer to these questions, but it will depend a lot on the context. And of course, this uncertainty creates a number of risks and it influences people's behavior, as Carole has also mentioned. But what I'm suggesting is that Article 4 of the National Security Law provides an excellent opportunity for universities to proactively develop responses and policies on academic freedom based on international standards. So the provisions in the ICCPR and the ICE-SCR can be referred to, and they might also be included in any training or other activities on academic freedom, which Carole has suggested. Finally, I just want to emphasize that these international standards also remind us that academic freedom is not just for the benefit of us at the university, in the academic communities. It's not just about improving rankings and the reputation. Of course, those are important considerations. But academic freedom, as Carole has also mentioned, supports the role that universities play in society more generally. And there are lots of examples of this. Again, the research on COVID-19 that has positively influenced policies. And I mean, I don't have time to go into a lot of the examples, but I think it's fairly obvious how important academic research is to society and how important academic freedom is to be able to produce and disseminate that research. So academic freedom is not an end in itself. And I think this insight might also be built into both the institutional and the individual responses to the national security law going forward. So I'll stop there. Thank you very much for listening.
Thank you, Kelly. So if you have questions for Kelly, please write them up, and Kelly will have a chance to read those questions, and I will answer the questions in due course. But I think there is the first case of cessation in court now. I think it will be heard next week before Justice Chow. It will. The question is precisely this: is national security law consistent with the basic law? So it will be interesting to see how the court would handle that particular issue. I'm quite confident the court itself is robust, independent. But my worry is something else. That is, we tend to send all the difficult questions to the court for resolution, as if that's the only way to provide a remedy, as if we are running away from the difficult questions. Whenever there's a question, we legalize it, and then we'll pass it on to the courts, and they say we wash our hands and say, well, we'll see what the judges say. Right? Probably, especially in our circumstances, I'm just worried we're burdening the courts too much. So that is my slight concern. Now let me move to our third speaker, Mr. Robert Krim. Rob is the founding ED for Scholar at Risk, SAR. It sounds exactly the Hong Kong SAR. Rob has been working in the field of academic freedom for decades. For me, he is the most influential person when it comes to academic freedom. So we're truly honored to have you, Rob, to share your insight with us. Rob is going to talk about comparative perspectives, lessons from abroad. Rob.
Thank you very much, Hua Ling, for a too generous introduction, and thank you, Kelly and Carole, for your presentations, and to everybody for taking part. I'm very impressed with the turnout for an early morning webinar on academic freedom, and I think it's a good sign for Hong Kong that this many people are paying attention to it at this early day. So I'm going to share some slides, and then we'll get going. As Hua Ling said, I'm the executive director of something called the Scholars at Risk Network. Just very briefly, Scholars at Risk is an international network of now over, I think, 530 higher education institutions in 41 countries, plus their faculty and students. And our mission is specifically to protect threatened scholars and members of higher ed communities and to promote academic freedom. So, of course, there's more available on our website. But in short, we have three areas of work: protection work, which is direct assistance for the most threatened individuals; advocacy work, which is essentially using the tools of the human rights movement and the legal community in a conversation with states about the importance of academic freedom; and then research and learning work, which is really using the practices and principles of higher education values in a conversation within the higher education sector. And of course, today we're sort of crossing the lines back and forth between the advocacy work, the conversations about with states, and conversations within the higher education sector. So just so you know, my disclaimer here, I am not an academic by training. I'm a lawyer by training and by choice in the human rights field. And so I have always viewed my role at Scholars at Risk, which is now in my 21st year, I think, as the lawyer for the human rights, for the higher education sector. So how do I help protect academic freedom globally? So the perspective I offer is not an expert on Hong Kong law, not an expert on the basic law or the PRC law, although I have some slight familiarity with all of them, and I have lived in Beijing for a year, and I have visited Hong Kong many times and am fond of both and the people there. So it really is an important issue, and I'm delighted to be a part of it. So my perspective comes from the cases. And by the cases, I mean the more than 3,000 cases of individual scholars who have come to Scholars at Risk and say, I've been threatened, as well as more than 2,000 documented incidents of attacks on higher education that our monitoring project has recorded over the last 6 years. And those come from over 100 countries and, as I said, over about 20 years of experience. So I always test whatever I'm saying against that case experience, what I hear from others against that case experience, and it's sort of the composite of that case experience that I want to share with you today, if I can. So you know, resources that we have tried to boil down that experience for those who want to take a deeper dive from the advocacy work. So that's the sort of human rights direction. We have our Advocacy Insider, which is a monthly newsletter of actions responding to attacks on academic freedom around the world. And of course, we would include Hong Kong incidents in those when we're aware of them. And our annual Free to Think reports, which you can see the 2019 report cover there, that will document between 300 and 350 attacks. There will be a special section on China and Hong Kong in the 2020 report that will be coming out this November. And of course, those are available on the website. Last year, we issued a special country report on China specifically and academic freedom issues that we were arguing are impeding China's pursuit for world-class universities. And so you can see the cover there. And again, it's available online in English and Chinese. And then I should mention also that we have faculty-led seminars and workshops for students and legal clinics within our global network, all aimed at exploring the human rights side of academic freedom issues. And then the other set of resources for those who are interested come from the higher education values side of these questions. So the non-legal but more policy and practice. And there especially our Promoting Higher Education Values Guide. It's a discussion guide as well as workshop exercises. And we have what is called Dangerous Questions, which is a MOOC, an online MOOC free course on why academic freedom matters. And you can see there's an animation from one of the videos in the MOOC. And anyone's interested, as again, can find that on the website. So that's my perspective, coming from that experience that we have tried to crystallize, and I'll try to share it with you now, and then I hope we can have a robust set of questions and discussion. So starting point from my view from the outside, again, not as an expert in any way pretending to be on the nuances of Hong Kong's situation, but it seems to me that we have two paradigms at the moment. And the one paradigm is we need to reaffirm the one country, two systems frame for Hong Kong, that the national security law isn't necessarily as bad as it seems, and we will use the tools of the basic law and the ICCPR and the Court of Final Appeals, as Kelly and Carole have already mentioned, and hopefully we'll get some good interpretations out of those, and so therefore academic freedom won't be overly burdened by this. So that's one paradigm. Whether that is or is not too optimistic is something we can probably talk about. But the other paradigm also, I think, is one that we need to think about, and that's what I would call a legal or juridical occupation. And whether or not that this law is so vaguely worded and so potentially all-encompassing, including for people outside of Hong Kong who don't ever go to Hong Kong, that really what we're looking at is a full occupation from the PRC system. And of course, that could mean through the Article 158 interpretation trumping paradigm one, but it could also just be applying direct jurisdiction over an action under the law itself. So I just put that out there so that when I tell you how I look at this, I have to hold both of those in mind. I said, because there is so much uncertainty that we have to keep both of those paradigms in mind as we move forward, because the uncertainty itself creates risks, of course. And so on the one hand, we have the legal and financial risks, and those would be for institutions, it would be for scholars, it would be students, and it has extraterritorial application. On the other side, we have the academic freedom risks, and that's where I want to spend most of our time, but I set them up this way so that we recognize that there are tensions between those. And how we address them is going to be important. So the first is there's a risk to the definition and scope of academic freedom. That there is a risk that we will fall into the trap that people have fallen into all around the world, of in an attempt to protect the sphere for academic freedom, we will concede in a way that academic freedom only applies in certain physical contexts, such as inside the campus but not outside the campus, in academic journals but not in general audience newspapers, and so forth. So, and I would urge us to strongly resist a physical contextual understanding of academic freedom. It's a myth that that is actually what universities look like at the moment, but it is a tendency even among defenders of academic freedom to slip into that in an effort to respond to perceived or actual threats. The second definitional risk is the myth, as I would call it, of safe topics or disciplines. We certainly know that there are some topics that are extremely sensitive, but Kelly already touched on that there are others that really should not be sensitive and are not sensitive, but are merely pursuit of truth. And that only becomes sensitive or dangerous when some authority doesn't like where the truth is going. And the most recent examples, of course, are researchers that have been looking at the truth of the COVID virus and trying to understand it for the betterment of public health. The next wave of those, of course, will be the researchers who examine the effectiveness or ineffectiveness of state responses to the virus so that we can have better responses in the future. And in both of those cases, we're going to see, we have already seen in the first, and in the second, we certainly will see attacks and pressures on scholars. So that first risk category is the definition. The second, of course, which Carole's already mentioned, is the risk of to the exercise of academic freedom. Even if we have a robust definition, if we're afraid to use it, that doesn't be very helpful. So we have an increasing risk of self-censorship. We have a real risk of paternalistic, and what I mean is well-intended, departmental or institutional actions that will have the effect of limiting either faculty or student academic freedom. And this is an example of where there is tension. So a well-intended administration or faculty member should exercise an attempt to assist students to avoid legal and financial consequences to their actions. But we need to make sure we do so in a way that we're not unintentionally trampling on the exercise of academic freedom and free expression. And then on the other side, there is also the risk of self-interested departmental or institutional actions that could be invidious, or they could be relatively benign, but have the effect of limiting academic freedom. So there's an understandable desire to retain the physical security of institutions against, say, police incursion, to avoid reduction in the reputation of the institution, but the actions taken to try to have those legitimate actions can have the effect of eroding the exercise of academic freedom. And then, as I just mentioned, there are quality and reputation risks for scholars, institutions, and the system. And all of these, again, are in tension. So if we maybe, for example, don't want to see an erosion of the quality or the reputation of higher education institutions as having full academic freedom, that creates a tension for us on maybe we don't want to fully report the violations or the challenges that scholars are having. And of course, that becomes a corrosive cycle. And I hope we can talk about that a little bit more. So that's for me the big picture. Keeping these two paradigms in mind and recognizing the different categories of risk, and especially recognizing the tensions between especially the different kinds of academic freedom risks and between the legal and financial risks. So now, lessons from abroad. The good news is that many places don't have two paradigms. Many places live under one paradigm that is a highly, highly restrictive paradigm, and going to the courts is really not in any way a viable path, and even going out to other actors within civil society is not a viable path. So it is, in a weird way, good news that Hong Kong has both, and that we hold both there. And so Kelly and Carole have already talked about essentially how to use the basic law and the provisions that are available to try to get good interpretations and good decisions, and I certainly support those efforts, and I certainly see why there's good reason to hope that the autonomy system that's in place will be able to be helpful in these circumstances. So I fully agree with Carole that lesson one is you have to be proactive. You have to be proactive. And I can tell you all around the world, this is very difficult to do. Until something happens, it's hard to mobilize people about something that seems like such a basic first principle. In fact, I will tell you, for the first 10 years of my doing this work, in many countries when I go, I'd have to spend the first 10 or 15 minutes explaining to people why they need to pay attention to the protection of academic freedom. So the sad thing is, in the last, say, 10 or certainly the last 5 years, the world has moved in a direction that I don't have to spend those 10 minutes anymore. Okay, the world has moved in a direction where people see that truth is under attack. The process of facts and evidence and reason are under attack. And so we have to really pay attention to that. So, but while you have the time, while you have the opportunity, before there is a true crisis, right now you have a law, but no real crisis from the law yet, you need to be proactive. And that means developing a culture and practice of academic freedom and academic values. And just saying shorthand here, I say values because when we do this work, we really don't just talk about academic freedom ever. We always talk about academic freedom in the context of 5 core values of higher education, with the others being autonomy, which we have touched on, but also equitable access, accountability, and social responsibility. And it's all 5 in harmony that make the university the special place that it really is. But for shorthand, we're talking about academic freedom at the moment, and I understand why. So developing a culture means going beyond the general statements and principles. Most universities in most thriving democratic states have principles of academic freedom on their website or in their charter. The question is, what do they do with them beyond that? And the answer is most, not much, until something happens, and then they scramble after the fact to try to put some substance into those principles, and it's often very, very difficult after the fact. So building a culture means constantly emphasizing why academic freedom matters. And Carole said it doesn't just matter to professors, and it doesn't just matter to students. Academic freedom is a driver of the quality of research and teaching, precisely because it protects the decisions about research and teaching into the domain of those who have the necessary knowledge, skills, and training to make those decisions. So it is fundamentally a quality argument. And I think it's really important that all of us who believe in academic freedom make that point up front all the time, because otherwise we leave the field to those who want to make the point that academic freedom is just a smokescreen to protect political or partisan activity. And it's simply not the case. It is a driver of quality, and we need to remind people that over and over and over again. I agree with Carole that there should be a complaint mechanism, but I don't think that goes far enough. I think there should be a mechanism, a responsible committee, a responsible office. There are some universities in Africa that have ombudspersons for academic freedom at the university that anyone can go to, but it also has to be proactive. It should be holding workshops and webinars like this one. There should be training for students, staff, and administrators, at least onboarding training. This is one of my pet projects at the moment, but law schools have required ethical courses. Medical schools have required ethical courses. Schools of journalism have required ethical courses. We expect professors to come into the discipline and know what academic freedom is. We don't train them on it. We don't explain to them how it's different from free expression, and it is different from free expression. And then we expect to have clear examples when we get to the real world. So I think that's a huge gap, and I think we should all look at how we can build in those proactive, positive trainings and so forth. And in specific, we should get to a better understanding of the meaning of academic freedom, which includes intramural and extramural expression. That means academics speaking within the campus, but also engaging with the public. And then what is the difference between that and free expression? And we need to talk about that. And then we need to talk about what's the difference between free expression or academic freedom and violent or coercive conduct, which is not protected by either one. They are complicated lines, but they're really important. And of course, Hong Kong and Hong Kong's universities have lived those complicated lines over the last several years and will continue to. So I support the idea that there should be developed by departments and by schools and by institutions guidance or FAQs for the community on academic freedom generally, but especially on the national security law. I think that would go a long way to helping to avoid the chilling potential and the self-censorship that the law could impose if there's just silence from departments and colleagues and institutions. I would strongly urge that those also include tracking mechanisms. The law is in part designed by being vague to create an uncertainty that will encourage people to try to avoid the legal and financial risks. And that is perfectly normal and understandable human behavior. But only if we expose the consequences of the law will we be able to make the arguments that the law is a problem and therefore firmly defend what is left of the academic freedom. So there's any number of ways that we could do this, but for example, being transparent when articles are not published because they, while academically appropriate and passed vetting, couldn't get past the vetting of the security law. Or if courses are not being offered that would have been offered before, but now are not because of the law, make it transparent, let the syllabus be out there in the world, and so forth and so on. There's any number of ways, but I think tracking that will be really important. There's a risk, of course, that that harms the reputation because it says we don't have full academic freedom, but I think that risk is much lower than the risk of eroding academic freedom if the consequences of the law are not transparent and are invisible. And aside from coordinating efforts within an institution, I'd also urge coordinating with other institutions if at all possible. And in Hong Kong, you have the advantage of a geography that's not so far apart that you can't connect. Of course, this is a difficult time and everyone is busy, but it's really important that institutions have a united front in this because it really is something that affects all institutions. So those are the good news. Lesson one, to be proactive within the university community. Quickly, I would also say be proactive outside the university community. That means engaging with those in government at whatever levels who may be supportive and sympathetic, if not specifically to the concept of academic freedom, then almost certainly to the concept of needing world-class research in Hong Kong, needing to be able to attract world-class scholars to Hong Kong, and so forth. And that connects directly to the business and industry communities, especially those who know they rely on the highly skilled sectors. There's a definite relationship between those sectors and world-class universities. And so there are natural allies there. And I think in particular, the education work to explain that academic freedom is about quality and academic freedom is not a smokescreen for partisan political activity is a very important point to get across. There may be opportunities to engage with police or law enforcement, at least to try to minimize the risks of physical harm to any actors when there are protests, unrest, or other forms of issues under the law. And I think someone earlier mentioned, but I would say there is no question there will again be student demonstrations. There will be. When they happen after the virus, we don't know, but we need to prepare now so that they can be happened in the most responsible fashion and that all the actors know how to behave responsibly in those circumstances. Bar associations, the Hong Kong Bar Association, I know has been very active on all the issues under the basic law for years. And I also know they have strong partnerships with international bar associations, including the City Bar Association of New York and other civil society groups. Academic societies have, I think to their credit, become more and more active on academic freedom issues. More and more of them have committees on academic freedom. And there are natural partnerships there to be built. There is a growing community of at-risk scholar and student support communities, of which Scholars at Risk is a part. And certainly we are ready to try to assist when we can. And then don't neglect the public, because the public is the first defender of the university space, or should be. But that takes the university making sure that it is of and with the public and that the public sees that relationship. There is a tendency by actors who want to curtail academic freedom to claim that it's an elitist thing and it's only for scholars, and we need to be able to dispel that. So those are the lessons 1 and 2. 3, we can't always be proactive because incidents will happen and we don't control the timing of those incidents. When they happen, we need to be reactive. When we do so, communication is essential. Silence after an incident does not help the cause of academic freedom. I know that administrations try to respond. They often don't have the facts. I know from Scholars at Risk, from our own monitoring work, it often takes us an awfully long time to develop the accurate facts, and sometimes it's almost impossible to get a full picture from far away. But even communicating what you know and what you don't know is better than not communicating anything to the stakeholders. Update guidance. If you did your proactive work and have FAQs out there, make sure you update them or review them after incidents to make sure they're still accurate. Think creatively about responses. There's a real tendency in these cases to fall into the trap of binary responses. The classic example is overseas higher education partnerships, and an incident happens at a campus, and there's a call from the home campus to cancel the partnership and bring everyone home. And of course, that's a very extreme response, and because it is so extreme, it usually almost never happens. And as a result, the institution often then does nothing publicly. So you end up with an all or nothing scenario, which is not helpful. So at Scholars at Risk, in our values work, we're trying to encourage the development of a response menu that gives us choices that are more nuanced and appropriate to the scale of the incident. So for example, there could be issuing statements, you could be holding teach-ins, you could suspend a program, you could shrink a program. There are any number of opportunities in between, and we need to be creative in that space. Encourage transparency, as I said, through documentation, including let us know about incidents so that we make sure they get into our global reporting. Certainly, I would say support the legal challenges that Kelly was indicating and Carole were indicating were possible, including defending scholars and students when charges are brought up against them. It's important that the community stand together. Don't forget the international mechanisms which are available through the UN and other venues. And where necessary in the extreme cases, organize material support for those individuals who are harmed because of the expression under academic freedom or free expression. And again, our community is available to try to assist with those. So in conclusion, and I apologize for the speed with which I've gone through this, trying to synthesize the 20 years of experience, there are certainly, I would say, many potential risks to academic freedom posed by the new law. It's uncertain whether, when, or to what extent these risks will ever materialize. But a wait and see approach is simply not a responsible strategy. You've got to be proactive. You've got to use the scenario or the paradigm one that you have and the time that you have. You need to build a culture of practice for academic values. If you do so, it will benefit the university, scholars and students, whether or not the risks of the national security law materialize in any case. It would be good to have anyhow. And if your community is paying attention now and can be mobilized, it would be good for all of you. You need to build dialogue and relationships within Hong Kong, including outside the higher education sector, especially to help them understand what academic freedom is and how it benefits the public. That could help to mitigate some of the risks under the national security law. Transparent tracking, I said, I think that will help to increase the costs, if you will, of the law and therefore possibly discourage its broad use in any case. And finally, build relationships outside of Hong Kong, especially with the support communities, so that we can help you increase the visibility of the law and any of its uses against academic freedom or academic communities. Again, for the purpose of discouraging that use and also for reinforcing and understanding the higher education community is not in opposition to any authority, but merely in pursuit of truth and evidence and reason that then can be used for better public policy and better public discourse. So there's a lot to be done, but I think you have a lot to work with. And I know Scholars at Risk and our network is eager to be as supportive as we can. And I look forward to a robust conversation.
Thank you very much. Lots of food for thoughts. I think you touch on at least 3 sets of dynamic relations. One is between the proactive actions and the responses after events happen. And number 2, you talk about academic freedom and the quality of research. And finally, you also touched on academic freedom and the academic responsibilities. I think going forward, as you said, there are lots of things to think about, lots of things to do on the side of the university. So do please send your question to Rob and to other speakers. So Carole, have you had a chance to look at some of the questions? So you want to go ahead to answer
Yes, I have.
them? Yep.
I've been trying to scroll through the questions, but also listen to the presentation. So apologies if I've missed some, but I have jotted down as many as I could. One of the first questions, which I think is very relevant, is someone asked if we could explain what self-censorship is. It's a term that we use a lot in this subject, but we should explain it. And basically, self-censorship means that rather than waiting for someone to tell you you can't write that article or don't write that article, you might not get tenure, or even worse, you might be prosecuted. Self-censorship occurs when someone, because they're worried about what might happen to them, they just censor themselves even before. So they themselves stop saying things that they think might be controversial, steer away from controversial research projects, maybe don't want to teach controversial courses. And so that's self-censorship. And the reason I use the example of RTHK is if you heard it on the news today, some people have really criticized RTHK because they had posted an interview that included Nathan Law, and then there are just these rumors that he's wanted by the police for violating the law, and the next thing we know, the interview's taken down. Well, there's nothing that I can read in the national security law that says it's a crime to have an interview in a public radio station with someone who maybe is wanted for violating the law. I mean, it's not like you lose your right to speak just because you're accused of violating a law. So that is, in my opinion, it was an example of self-censorship. I don't know who made the decision at RTHK or why, but it sure looks like self-censorship. And jumping ahead to a few questions, there was a comment in the chat where someone said, I just want you to know it's happening already at Hong Kong U, a lot. And that doesn't surprise me, because even when I did interviews in 2015 and 16, I found far more interviewees tell me I am self-censoring, or I'm telling junior colleagues who don't have tenure yet to self-censor. So I think it is a real problem. The second question that I think I jotted down was, in light of Article 55, rather than focusing on how we hope the Hong Kong courts are going to interpret the law, maybe we should be trying to promote liberalization in the People's Republic of China, because the NPC Standing Committee has the ultimate power of interpretation, and the courts here will have to follow the interpretation. And under Article 55, you could find your case transferred to the mainland. And I can see the wisdom of that, but I think right now there's not a lot of optimism about promoting in the short term liberalization of the political system in the PRC. Hualing might be able to add more to that, but I think, in my opinion, we need to focus more on what we hopefully can influence. Another question that was posed, which is a little bit related to that, and so I'm going to jump ahead a little bit, is, isn't it perhaps dangerous, one person said, to be proposing guidelines along the lines that Robert and I have suggested, because you might actually almost trigger an NPC Standing Committee interpretation. In other words, oh, maybe the NPC Standing Committee never thought about whether an article about South China Sea territorial disputes might violate the law, but let's now interpret it to say you can't write that article. I think that's what the questioner is raising, if I understand the question correctly. And I suppose that is a possibility. I guess for me, if I were still teaching at the University of Hong Kong, and I taught in Hong Kong for 17 years, I'd like to know, if I could. It really bothers me that there is so much language in this law that is so vague and so subject to interpretation. I take your point that it's possible that by raising an issue, you might trigger an interpretation, you might get an answer that you don't want, but I actually think that, and I could be overly optimistic here, but I don't think that the central government wants to be seen as overtly violating the ICCPR in Hong Kong. I mean, why did they put the language of Article 4 into the national security law? I think they put it because they wanted to be able to say with a straight face to the United Nations, oh, the ICCPR and the International Covenant on Economic, Social, and Cultural Rights, and all the other human rights provisions in the basic law still apply in Hong Kong. That's what it says, the people still enjoy these rights. Well, if Hong Kong U and other academic institutions start drafting guidelines, providing interpretations or guidelines for their faculty that promote interpretations of the law that comply with the ICCPR, and then if the NPC Standing Committee steps up and says, no, you're wrong, we meant to violate the ICCPR. I think that would be rather embarrassing for the central government. So I may be overly optimistic and other commentators may have a different view, but to me, I think it's still valuable to try to push at your departmental, faculty, and university level for the most robust definitions of academic freedom and for narrow definitions of these offenses so as to comply with the ICCPR.
Can I ask Rob to respond to that? Or will he raise his hand? Yeah.
No, it's not a response, but actually it's a question for Carole that I was thinking of during your presentation. And I have no problem with, as I said, keeping both interpretations in mind, the optimistic and the pessimistic. But it seems to me that Article 20, if you read it in the best possible light, is about you can't destroy the territorial integrity of the country. But they didn't write it that narrowly. So that also seems like a choice, right? Because I think there's a way to write that kind of a law that would be perfectly acceptable under any legal system. So do you think that was just bad drafting or choice? And do we have any way to know?
Well, we really don't know for sure because none of us were in the room and because there was no public consultation on this law. In a normal legislative process, a draft of a bill would be published, people would ask questions, people would write commentary, and then the legislature would consider, oh, maybe we didn't make that clear enough, we meant this, and now we're going to clarify it. But because this law was drafted so secretively and then promulgated, right, the moment you saw the law, it was enforced. So we haven't had this time to seek clarification, and that's usually what happens in a public legislative process that complies with ruled law. So that's a problem, we don't really know. My own opinion, and it's just my best guess, is that the law was deliberately drafted in vague terms to have a chilling effect. So you read Article 20 and you think, oh, that could be really, really broad. But then you also have Article 4, which says all the same rights that you had before under the basic law continue, so that the central government and the Hong Kong government can say to the United Nations and the Human Rights Council, nothing has changed, right? So I don't know, Hualing, you might have a better informed idea, but to me, I think it was deliberately vague and in some cases deliberately contradictory, because I do think there are some provisions in the law which do clearly conflict with the ICCPR. And I can't think of any way to interpret them to make it comply with the ICCPR. But the definitions of the criminal offenses, these four main offenses, I do think have a lot of room for interpretation. And I really hope that universities and academics can put forth interpretations that do comply with the ICCPR and that they will not be disrupted by the NPC Standing Committee. Of course, I can't be sure what will happen, but that would be my hope. Hualing, you might want to add something to that. Do you have any ideas about whether it was deliberately vague or bad drafting?
I think the secession is drafted in the same way in the Chinese Penal Code in the past. I think probably my personal guess is there's no better way to narrow it down. It's about integrity of the territory. Beyond that, probably they feel it not really necessary to give more details. Leave it to the enforcement, leave it to the courts at the application level. I probably is a I won't call this bad drafting, but it's just a habit of drafting on the Chinese side. So in that sense, I do think Article 4 is important, right? I think in a way that's the first time in a Chinese legislation to write ICCPR into the law, right? The right to silence, presumption of innocence, which has never happened in the history of Chinese legislation. So in a way, it's as bad as the law is. Those articles at the very beginning of law, for many of the mainland scholars, are quite inspiring. It's really now have one article. Of course, it's written mainly for Hong Kong, but not exclusively for Hong Kong, because there is a national jurisdiction could be triggered by 55, right? So the wish for hope, the thinking is maybe someday those articles will be smuggled into the Chinese national legislation, not only for Hong Kong, but for that would answer part of the question of the one of the speakers. So why do you need to wait for China to liberalize before anything can be done? I mean, it is a process. I think the court would have the room to interpret the legislations, I think. We'll say, I must say that there are cases coming up very quickly. We'll see how the justice child is going to do this balancing between security and the freedom. Should I move to Kelly to answer some of her questions before I move to Rob?
Sure, thank you. I think somebody asked about the Human Rights Committee's review of Hong Kong's report under the ICCPR. I was hoping to have time to mention that, but I didn't. Yes, that's actually happening now. It's in process. And the Human Rights Committee has just published its list of issues. So basically questions about Hong Kong's implementation of their obligations under the ICCPR. And now the Hong Kong government will have to reply to those questions. And then probably next year, I'm not sure if the hearing is actually scheduled yet. It's not yet, okay. The Human Rights Committee will actually meet with the Hong Kong delegation and ask more questions and come up with concluding observations and recommendations for Hong Kong. The list of issues does mention academic freedom in the context of freedom of expression. And, you know, it doesn't go into a lot of, it's not a detailed question, but it's there. It's not, there are several questions about the national security law, and it's not included in that section of the list of issues. But, you know, it may be that they will ask questions about academic freedom in relation to the national security law, along with the other concerns that they have about how the law will be implemented. Getting back to the issue of the courts, there are a couple of questions about how, you know, won't the courts be under a lot of pressure? And others have already touched on this a bit, but I just wanted to mention that there have been comments made by foreign judges. So I think there's a UK judge who sits on the Court of Final Appeal as a non-permanent member, saying that, you know, depending on how things go in Hong Kong as a result of the national security law, foreign judges may not be willing to come anymore, right, and sit on the CFA. And I think that it's interesting because there's pressure on judges, perhaps, you know, not to seek an interpretation from the NPCSC and be cautious, but then there's pressure from foreign judges, sort of counter pressure. And it may be that, you know, a judge doesn't want to be the one who makes that decision that actually leads to foreign judges saying, oh, the rule of law is dead in Hong Kong and therefore we're not coming anymore. So, I mean, there's sort of a collegiality and some international pressure in that sense, perhaps. There was a question about primary and secondary education, which actually I'd be interested in hearing what others think about that. There is mention in the Committee on Economic, Social, and Cultural Rights general comment on the right to education. They do say that it does also cover, academic freedom also covers primary and secondary education, or at least secondary education. But it's particularly important in higher education because in their experience reviewing state reports, they've noticed that there's a lot more pressure on academics at higher education institutions generally. But obviously in Hong Kong, we're seeing some pressure and at other levels of education. Finally, I think the other question I noticed, sorry.
You have a second round for there because questions are continuing to come. So can I just invite Rob to answer some of the questions?
Sure, yeah, as quickly as I can. So, and thank you for all the good questions, because there's really a lot in there. It says, will Hong Kong universities support individuals who run afoul of the law, and if so, how would that work? So obviously I don't speak for Hong Kong U, and I won't answer that, and I wouldn't ask anyone to answer that, because it's going to be very difficult. But I would say, recognizing that we're not really in a two sovereign situation, but we are a two system situation. There are lots of examples around the world of institutions of higher education that are in a two sovereign or a different sovereignty, and what happens to their students. So there's lots of universities in the Gulf, of course, there's universities in mainland China, and so forth and so on. So there is a lot of experience out there. In general, I think the thing to make sure people know is people will always ultimately be responsible for their individual conduct. Institutions always try, especially before incidents happen, to try to educate. And I think that's what we were talking about, educating as much as possible. But when something happens, I think the institutions also try very hard to assist their individuals when they can. But it is a very, very gray area. And I think it's an unavoidably gray area, because it's very hard to fully write down what we will or won't do and essentially indemnify individuals for conduct that you don't want to know what it is. Skimming, I had it. Is the national security law so unique in the world? I would just agree that, of course, there are national security laws all over the world. I would also agree that many, 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 many of them are abused and used improperly to limit expression and academic freedom. And in fact, that's one of the issues our research projects are looking at, is not only national security laws, but defamation laws, sedition laws, lèse-majesté. There is a body of law that essentially tries to prosecute expression by the state, and so that's certainly Hong Kong is not, or China would not be unique in that circumstances. The quality ranking questions, how do they take account of academic freedom? My answer would be not enough. Most of them claim to have it built in, but don't really explain how they're measuring it. We are in a much better position now than we were a year ago, because in March, in a project with partners in Germany, we were able to help create a new academic freedom index. So you can search for Academic Freedom Index online, and you will get the index. It ranks most of the countries in the world, but not all. Hong Kong is ranked, and that data set will come out now every year, and we'll be able to measure improvements or degradation of respect for academic freedom. And now our challenge is to get the ranking agencies to either adopt the index or otherwise build in more robust factors of academic freedom. And there's a report on the website. It's called GPPI is the entity, the research entity in Germany. And there's a report there about how the ranking institutes could get involved there. And I'm sorry, there was one more, but I think I have lost it.
Okay, I think I could. I have seen some of the questions. I can raise those questions, see whether I have any insight. I think the first question is, in a time of uncertainty and a time without proper guidance, should senior colleagues, administrators advise junior colleagues to self-censor themselves? Because we don't know, therefore don't touch it. Because we don't know whether that's a sensitive area, so don't do it. Should we do that? Or should we do something else? That's the first question. Second question is, are there, say, guidelines and the rules, code of conduct elsewhere in foreign universities that Hong Kong could follow, so that we don't have to reinvent the wheel every time we have difficulties, right? And the third question is related to the first one is, we have students who have faculty, we have a junior faculty, we have a tenured senior professors. Do they have different responsibilities?
Yeah, so I can jump in and then see Carole, I think. So sorry, on the last one, yes, of course there are different responsibilities, although everyone is responsible for their own conduct at the end of the day. But we do expect, as you go from an entry-level new student in higher education up until a very senior academic or administrator, that one's experience should be brought to bear on these issues, and therefore it does affect it. On the first question of should we coach people or advise people to self-censor, I think it's an appropriate question, but I think it jumps over the more important step that we too often jump over, which is, have we had conversations and given advice on the parameters and risks as best we can so that they are informed and can make reasonable decisions based on a risk assessment. So, and if we don't do that, then we're essentially doing maximum self-censorship. Whereas if we have been proactive and set up a system where we can reasonably, as best we can, assess the risks, then we maybe, even if we still end up with self-censorship, end up with minimum self-censorship. And I think that's very important. I do respect that in both professional and personal relationships in higher education, we do look out for each other. And so therefore, advising people to stay away from certainly red lines is not an appropriate thing. The question is, are we doing it in ways that are unnecessarily harmful to academic freedom, and are there more productive ways, such as more transparent ways or other, that we can allow people to have their careers, but also not lose the path of interesting inquiry that we would want to have. And I'm sorry, I think I missed or forgot the middle question, Wally.
Are there foreign examples that we could follow? Yeah.
Yes, I wasn't trying to duck that one. So we're overdue in trying to help create one. And if people are looking for it, we would love to try to help create a set of FAQs. Of course, Hong Kong colleagues would have to do the FAQs on the law itself. But I think the answer is no. I think there's a lot of general information about academic freedom, but there isn't a lot of very specific guidance. Part of that is because it is very complicated and slippery and fact dependent. But I think we could do a better job of giving people some clearer instruction about the basic elements.
Thank you. Carole, anything to contribute?
Yeah, I would just add, I mean, there are, obviously you can go to other universities and see what their academic freedom policies are. And we know, for example, you and Hualing and I were talking last night over the email about Australian universities are re-examining some of their academic freedom policies. So I think it is useful to go out and look, and certainly if we're going to do some kind of project, which I would support, we could help by doing that. But as Robert said, it's often very fact specific, and sometimes different universities are worried about different issues. So for example, in some American universities, the tension on academic freedom right now is over whether professors should have to put content warnings into their syllabus, right? I know professors who really object to that. And I often want to say to them, you don't have that much to worry about. Right? It's not that big of a deal. You should see what the people in Hong Kong have to worry about. But so what I'm saying is that it's sometimes a model code or set of FAQs from another university might not help you that much because it doesn't address the concerns that you have. But it's certainly worth looking at still. One question, Hualing, that I saw scattered come up quite a bit in the in the chat, but I don't think any of us have really answered is, what about students' academic freedom? And so I'm wondering if maybe some of us could address that because it's come up more than once. And my own quick answer to that is, yes, students definitely have a right to academic freedom. Part of that is just their general right of freedom of expression, freedom of assembly that Kelly talked about. That all applies to students just as much as to academics. But also the basic law provisions that I mentioned do refer to students' right of choice in education. And I think this is going to be very important, especially if the government takes a very proactive role toward Article 9. You know, Article 9 is doesn't create a criminal offense, but it creates this duty for the Hong Kong SAR to strengthen measures to offer guidance, supervision, and regulation on matters concerning national security, including those relating to schools and universities. And one of the people in the chat raised a very good question. What exactly does that mean? Is that some kind of positive duty to promote the national security law? And if so, who's going to teach that course? Hong Kong U, right? So I think Kelly just raised her hand. Maybe she wants to teach it. I don't know. But I think that it would be useful for universities and secondary schools as well as Hong Kong to really start thinking about what is the academic freedom of students, and at what point might some patriotic education program actually infringe upon that, unless students are allowed to talk about controversial issues and hear opposing views.
One thing we are doing here is, so we used to send law students to high schools to teach a little bit of constitutional rights. I think, but then our students would have to familiarize themselves with the national security law before they can go out. I think the prevailing concern is not talk about any of that, right? I mean, the first question, I was asking our students, say, anyone can help me to build a website on national security law. Lots of people said, yes, I'm willing to help, but the condition is my names will not show up. So people will not know that I contributed to a website. So that is the level of concern, right? So the question is what we're going to do about that. Clearly, fear is never rational in itself. That's why you call it fear. There's uncertainty out there. So I think that's a big question. The only thing I can say to students is, well, I think if you're not ready, then don't do anything, don't say anything, right? Just be a law school student. There are others, right? There are tenured professors out there. They probably will be more vocal to speak on your behalf. If you have a concern, come to us. We'll just express those concerns for you if you don't feel comfortable expressing yourself. But beyond that, it's really difficult to say what can be done, especially to address the concern of students. Anyone else to just add on this student dimension? Rob and Kenny, yeah.
Yeah, so I would just say, yes, that's certainly, at least by the definition of academic freedom that we at Scholars at Risk use, students do have academic freedom rights. But I would flag that when they are then claiming to exercise those rights, they also have the same responsibilities as other members of the academic community to exercise them responsibly in intellectually honest ways, with evidence behind what they're doing and so forth and so on. So there is a difference between academic freedom protected expression and general free expression. And I think we can do a better job helping to explain that. Students have rights in both categories, of course, but and particularly the issue of organized student expression, so essentially student protest, whether inside or outside of the campus may be protected by academic freedom. It depends on the context. But of course, that is a very, very common flashpoint. And in our academic freedom monitoring project, I think roughly 60% of all of the incidents that we track each year start out with or involve student expression, organized student expression, that ultimately turns violent. So it's an area that's fraught. It's an area that's hungry for academics and NGOs to get involved in giving better advice. But certainly there is a role of student academic freedom, but also responsibility with it.
Kelly?
Actually, I don't want to respond. I have a question for you, Hualing, about Articles 9 and 10, which Carole mentioned. And I think there were a couple of questions about it in the chat function. I've heard that the Chinese version is different from the English version. So universities is included in the English version, but not in the Chinese version, although it might be interpreted to be included in the Chinese version. But I'm just wondering if you have an answer to that question, and do you think that universities will be asked to teach or add something about national security to the curriculum?
Right. The first answer is I don't know whether. So in the English version is in Chinese. Well, there's the potential contention. What's the meaning of school in Chinese and English? But putting that legislative language aside, I think it will be very difficult for university to say no, that we don't talk about national security when the government is requiring the entire society to talk about national security. And the one strategy is, we're doing this, right? This seminar is about national security law education discussion. I will actually encourage the law schools, the university in Hong Kong, just engage the law. I think the difficulty is to face up to the challenge. If there are concerns, well, talk about those concerns. because you cannot just hide, you cannot run away from those concerns. So they will come after you, right? If you don't face up to it. So in a way, I don't really mind. There's something that the university would be, talk about national security law. Though of course, we say what is a proper education. For me, a forum like that is educational. Right? We participate, we debate, then we could clarify our doubts. Right? We decide sort of a roadmap going forward. I think it's tremendously important, at least for me, to have a proper understanding as to what a faculty can do. Some of the questions, I would not have thought about them without looking at those questions. So the debate, deliberation is an essential aspect of the law. I think even for the judges, they will have to look at academic debate. What law professors talk about interpretation, Article 4 and other articles. I think they need sort of education as well. It's the entirely new, uncharted water so for us to navigate. So it's a difficult issue and difficult for every one of us. There's one question I think Rob touched upon. That is to sort of a partnership with law enforcement. Right? It's a bit sensitive. I'm just wondering how the university is going to touch base with the national security agencies in Hong Kong, and if say we send the invitation, so what we're going to talk about. Any comments, elaboration on that point?
Well, so again, I would look to models from other places, right? And one of the things we have seen really over the last couple of decades is, at least in the US, but also other countries, a militarization of campus security that can lead to things getting out of hand when student expression or other expression on campus happens. And I say other expression because we also have incidents where it really isn't the university community's expression, it's outside actors coming into the university space, and that's a whole other issue. But the question is being creative on, are there opportunities to explore dialogue? And what is the culture or history of autonomy of campuses in a physical sense? Do police inform when they're coming on campus for purposes or not? Are there ways to, even if it's not formal agreements and positions, to build understanding, including to build understanding on the part of the university community of the boundaries of protected expression and where violence begins and protected expression has stopped, and building on the side of public security and understanding that expression in different forms is protected, and that the community understands the limits. So I certainly understand those who would be cynical about the likelihood of being able to form signed agreements with certain types of offices or law enforcement. But we do have some examples. In the US, we have some immigration issues where our federal government's immigration laws are not supported by the local jurisdictions or by the campuses. And we do have some examples of universities reaching out to the local enforcement offices and trying to at least develop relationships that have been productive. They haven't changed the law or the policy, but it may be a way to minimize or reduce some risks.
Thank you. This is very helpful. Any other questions you want to answer? There are loads of questions out there. Yes, Carole.
Yeah, there's a couple that I would like to answer. And first I want to say a big apology to anyone whose question didn't get answered. There's a lot of really good questions. And if anybody wants to pursue the conversation, my email address is right up the University of Hawaii at Manoa website for the law school. And feel free to email me. But two questions that really I think need addressing is, one question was, what if the risk doesn't come from the security establishment or the police, but from within the university? In other words, a tenure decision is denied, or you don't get your PhD because someone was trying to interfere with your academic freedom, and what can we do? And that is actually why I used the Robert Chung affair as an example, because Robert Chung, first of all, was a student at the time. He was a PhD student when he was first told to avoid a particular public opinion polling project. Secondly, he felt that he had nowhere to go in the university because it was coming from the various highest level of the university. And so basically what he did is he kept quiet until he felt he was a little more secure in the university. He had his PhD, he had a position, and then he went public with it. But that is why I think Robert and I are urging people to try to push for a complaints mechanism. I like the idea of an ombudsman. I think it's important to have people in each department to receive complaints. And there should be a very strong message from the university that violating academic freedom is a disciplinary offense, right? That if you as a department head or a member of a tenure committee punish someone for their academic views, then that should be a violation of your duties as an academic. And the pro-vice chancellor had to step down from his position. The vice chancellor had to step down entirely from the university. But it really only happened because Robert Chung had the courage to come forward, and so many other academics supported him. And at the time, the council was a lot more representative of the university community. So what can we do? The setting right now is much more challenging than it was in 2000. And so I don't want to be overly optimistic, but I do think that developing policies and really putting the university senior management on the line. This is a policy we want you to endorse. And if you don't, well, we're going to go to the international community and we're going to tell the UN Human Rights Committee and Scholars at Risk and everyone who is interested that Hong Kong U did not endorse the policy that the academics suggested. Put them on the defensive, make them justify it, because they don't want to be viewed as a second-class university. The universities in Hong Kong are very proud of their reputation. Even in Beijing's white paper on Hong Kong in 2014, there's a long paragraph bragging about the international reputation of Hong Kong's universities. So I think one has to make it clear that if you want to keep that reputation, then you need to strengthen academic freedom, not just a policy statement, but mechanisms to promote it. And then the last short question, I know I've gone on too long, but a couple of people asked questions about funding. One person in particular in the chat said, I've already been told that if I'm applying for PhD funding, don't mention certain controversial topics, things that might offend the central government. And that's a clear example of self-censorship. It might be paternalistic in the sense that the person who's advising that PhD student might thought I'm looking out for the PhD student, but it is self-censorship. And it is very, very worrying. And one of the other questions came from what are the implications of foreign academic collaborations if funding is found to come from a suspect foreign organization for a purely academic program in Hong Kong? Would there be risk of liability? Will this have a chilling effect on exchange? And I think, yes, it is designed to have a chilling effect. I really think it is. And I hope that drafting robust policies to try to make it clear that straight academic research shouldn't be viewed as one of these 4 criminal offenses, or even as aiding and abetting any of the offenses, will help to reduce that chilling effect. But it is a danger. And one person put in the chat, are you confident that academic freedom is not weakened after the national security law? And of course I have to say no. I mean, I think the national security law has put huge burdens on academics and on students and made it much more difficult to defend academic freedom. But all you can do really is do your very best to try to use the tools that are there. And I thought Hualing's comments about the significance of Article 4 are really interesting. And let's try to make the best of it and the best of the institutional mechanisms that we can develop from the bottom up. Thank you very much.
Rod and Kelly, any comments?
Sure, just quickly on a couple that were there. Number one, there was a question about the scope of academic freedom and how do we define that scope if we say it applies outside the university. I would just point that person or others to the workshop handbook that I mentioned at the beginning. It's called Promoting Higher Education Values, and it's got 4 pages that really summarize how we work on the scope of academic freedom right there. I said something earlier, then I saw the question afterwards. The question was, are there any statements as model statements, university statements? And the answer is yes, there's lots of university statements on academic freedom. You can find them all over the internet. When I said that no, not really, I meant there aren't a lot of FAQs or really detailed questions about the difficult scenarios that come up. That's a little bit different. So, and that's what I think we hope to work on. There was one question that about the self-censorship and how do we expose it or measure it and so forth. So, and I just want to say Scholars at Risk is working on a project to measure self-censorship, to have academics self-report levels of self-censorship. We hope to roll out a report on self-censorship in the Middle East at the beginning of next year. And so I'll put the plug in here. Of course, we would love to work with researchers who are interested in Hong Kong to see if we could apply the vehicle there and see if we can cast some light, because I describe self-censorship as the dark matter of the academic freedom universe. It's absolutely everywhere and really hard to see and really hard to measure. And then last was, there's a question that says, really just a statement that said the national security law is for violent protesters and not for scholars. And I certainly understand people have that opinion, but I'd point out that anything violent protesters did that was violent was already criminalized. There is no need for a new law to do that, and there's certainly no need for a law written as broadly and as vaguely as this one was, which really creates evidence that this law was aimed not at already existing criminal conduct, but at ideas. And one of the things we say in our work, when people ask me why do scholars get targeted so much, I always say it's because they stand at the intersection of power and ideas. And when power doesn't like the ideas, that's when attacks on universities happen. And so we have to see how this law will play out, but I think the evidence suggests that this law was in part clearly intended to squash the transmission of certain ideas.
Thank you. Carole, you have the final word? No? All right. So, all right. So, well, it's about time. It's you know, it's almost 2 hours. So, I want to thank the speakers for spending the time with us. Rob, in particular, thank you so much. I think we'll keep in touch with you for your insight on many of the issues that we are facing. And I want to thank the audience to spend the Saturday morning with us on this academic. People say it's ivory tower issue, but actually it's more than ivory tower issue. Just the 2 things I want to say before we end the session. First, we recognize the challenges that facing the university, the faculties, professors and students. The challenge probably is more in terms of the uncertainty the law is presenting. We just don't know whether the old rules will have to be changed, what is new. The uncertainty of creates concern and fear, suspicion. So that is, we need to have more discussion in forum like that. So that's number 1. Number 2, I think we are still here talking about that. We are a resilient institution. Hong Kong society is resilient. So over the past 2 days, I've heard, we're dead or over, it's finished or ended. I think one of the newspapers said that Beijing has changed Hong Kong in 1 single day. I don't think anyone can change us in 1 single day. Will never be changed in 1 single day. So I think it's just like a process, right? We have to face the challenge. It will be difficult times ahead. There will be lots of discussions within the university, within the faculty. So hopefully we could come up with something. It will be a Hong Kong EU model or something else that Rob will be agreed on, and we'll use that in other occasions. So on that note, I want to thank the speakers for your wonderful presentation and very exciting exchange. And also thank the participants, the audience, again, for spending your morning with us. I look forward to seeing you in the near future. We will be organizing other seminars on different topics, freedom of the press, police power. We may return to academic freedom again, if we can move ahead with some success. So on that, I wish you a good night and good Saturday afternoon. Thank you.
Thank you very much.
Thank you.
Thank you.
Thank you.